Chris Hipkins.
Thank you very much, Mr Chairman. Mr Chairman, I'm very pleased to take a call on this new Part 5 of the Housing Legislation Amendment Bill. And before I begin my comments on the specific provisions of this, I do want to acknowledge the growing levels of frustration on the benches opposite. And I want to say that the power to end this debate is entirely in the government's hands. If the government is willing to send Part 2 of this bill back to a select committee so that the confiscation of property rights can be adequately considered, then the debate will be all over. But if they're not willing to do that, then the debate will continue. So the power to end this debate is entirely in the government's hands. I suggest they have a conversation about that. But moving to Part 5 of the Overseas Investment, Part 5 which amends the Overseas Investment Act, to consider basically a housing interest test, an interest test when overseas buyers are buying New Zealand housing. The question that we should always ask about overseas investment, and I stand here as someone who supports overseas investment in New Zealanders, but the question that we should always ask about that is, what is the benefit to New Zealanders? What extra are we getting from the overseas investment? So if they're buying a business, we've got good tests around, well, what would the extra investment mean for New Zealand? If they're buying sensitive land, we have a test that says, what extra do New Zealanders get from this purchase? And why do we not have similar criteria around overseas investment in our housing market? Surely the question that we should be asking is, what are we getting? If we're allowing somebody to come who is not resident in New Zealand to buy housing, what is the benefit to New Zealanders? At the moment, no such test exists, and this provision inserts that. By doing so, it would prevent an overseas investor simply buying up residential properties for the sake of raking in profits, which are then removed from New Zealand, which push up the price of rental accommodation and exclude New Zealand buyers from the housing market. And it would ensure that those houses would otherwise be available to New Zealand purchasers, first home buyers potentially, or other New Zealand-based resident investors. So why do we allow unrestricted overseas investment in New Zealand housing at the moment? There really isn't any good justification, because if we go back to that very first test around what value does that deliver to New Zealand, arguably it does not deliver any. So I want to turn particularly to the clauses around 17B, which talks about assessing the value of overseas investment in New Zealand housing. And I want to talk particularly about 2A3, which is where an overseas buyer is purchasing existing premises used or intended for occupation by any person as a place of residence that is not currently suitable for habitation, and the relevant overseas person is committed to redeveloping that site to make it fit for habitation. We've got a number of buildings throughout New Zealand that at the moment do not meet code. Many of them owned by local authorities, but some of them privately owned. Some of those old housing corporation blocks, for example, that need significant improvement in them, that they are now privately owned, no longer owned by the housing corporation. They need significant improvement in their present form. While some of them, regrettably, are currently tenanted, they are not suitable for human habitation, and it's an indictment on our current housing policies that we've actually got people living in housing that is currently not fit for human habitation. But if an overseas investor was to buy those properties that are so badly run down that they cannot be occupied without significant investment, and there is nobody else, that's the other test that has to be applied, and that there is nobody domestically who would be willing to make that investment, then they are going to be increasing the supply of housing for New Zealanders, and there could be a case to be made for the overseas investor to be allowed to buy that, because those dwellings are otherwise unoccupiable, and without that overseas investment, they would not be occupiable. And so there could be a case made for that. This bill introduces that, and it allows for that to happen. But I actually think that the threshold would have to be reasonably high, because, as I've indicated before, the second test has to be whether there was somebody in New Zealand who would be willing to do that and make that investment. And if there is, then there's no justification for the overseas investment either. So it's not just a question of, does the opportunity exist? The question, the test then also has to be, and is there nobody else who could take up that opportunity, or who would be willing to take up that opportunity, or who would have the capital available to take up their opportunity? Because New Zealand housing should be for the benefit of New Zealanders. And we as a parliament should certainly be making sure that New Zealanders are the first in the queue, Mr. Chairman.
Mr. Chairman.